15 minutes we had told that only. So you start now.
Chapter 1, Your Lordship, page 1 of the written submissions.
Submissions on behalf of the petitioner, West Bengal, correct?
Yes, Your Lordship.
Kunal Mimani,
Yes. He's the advocate on record, Your Lordship.
Okay.
Yes.
Yes. What's your good name?
Your Lordship, Mahima Cholera.
Mahima
Cholera.
Are you with Mr. Sibel or are you with independently in this brief?
Independently with the law firm, Your Lordship.
Which law firm?
Your Lordship, Fox and Mandel.
Okay. Yes, please proceed.
Yes, Your Lordship. Chapter 1. Whether in the Indian federal structure, each and every state in the country is constitutionally or even otherwise legally obliged to match rates of dearness allowance for corresponding periods as that fixed by the central government. Constitutional framework. The constitutional position in respect of aligning the payment of dearness allowance by the Union of India with the DA paid by any state government is the question for determination. It is a settled position of law that payment and the rate of payment of DA at the level of the central government is at its discretion, since workers to whom DA is to be paid needs to be cushioned because of the rate of inflation which is stipulated by the All India Consumer Price of the central government. Entry 70 of List 1 of the 7th Schedule of the Constitution refers to Union Public Service Employees, All India Services, Union Public Service Commission.
This Mr. Sibel has already argued.
Yes, Your Lordship. So, Your Lordship, I can skip to para 7.
Yes.
A mandamus seeking DA at a rate that is separate from the notifications issued by the state is not available to the employees because they seek to demand more than what they are entitled to in law. Therefore, this Honorable Court has to decide the basic question whether on the basis of the notifications issued by the state government, it has committed to paying the DA with reference to the AICPI. It is submitted that there is nothing in the notifications to suggest the same. Your Lordship, the notifications mentioned here are the ones available at page 168 onwards.
Yes.
The AICPI only stipulates the rise in the rate of inflation on a monthly basis, which is taken into consideration by the central government on the basis of the explicit recommendations of the 6th Pay Commission to fix the rate of DA. That is the exclusive right of the central government.
Mr. Ahmadi, she is doing a very good job.
Yes.
Yes, continue.
If the central government were to issue a circular that all payments by the states of dearness allowance must mandatorily conform to the AICPI, such a circular would be per se unconstitutional. Therefore, no court can issue a mandamus for calculating the rate of DA on the basis of the calculation reflected in the AICPI unless the state governments explicitly state so in their notifications. In our case, Your Lordship, our notification does not have such a statement. The intent of the state government of West Bengal in issuing the notifications is reflected from the contents of such notifications by which it fixed its own rate of DA. It is submitted that the state government had no intention of following the central rate of DA, and hence the notifications themselves issued from time to time have no reference to it. Hence, the state government has demonstrated its intent that there was no commitment to follow the AICPI. On the other hand, there is no challenge to the different notifications containing the rates of DA declared by the state from time to time in any of the courts below, and neither have they been set aside either by the tribunal or the High Court.
Yes.
The attempt of the respondents is to suggest through a process of interpretation that even though there is no explicit commitment, in fact, the intention is to the contrary. In the various memorandums, the Honorable Court must read into it a commitment on the basis that the whole purpose of the AICPI is to protect the salary of the employees and to cushion them on the basis of inflation. What the law does not permit directly cannot be done indirectly. The rate at which the DA is to be given by the state government is based on several factors, including its fiscal position, priorities, and capacities, which differ from state to state. The employees of the state government, in fact, have been given benefits which employees of the central government are not given. Your Lordship may note that details of these benefits are at paragraph 11 and 12 of our application.
Yes.
All these factors have to be considered, which are to be determined by the state government. Hence, a proposition of law that leaves no discretion in the hands of the state government would fall foul of the constitutional scheme. The Parliament or Union Executive may legislate or issue executive directions on matters within the exclusive domain of the state legislature or executive under Article 252 and 73 only, with consent of the state concerned, not unilaterally.
Correct.
Accordingly, imposing the AICPI, published and revised under the Union Ministry of Labour and Employment, for determining dearness allowance payable by state to its employees without such consent encroaches upon the exclusive domain of the state and is therefore unconstitutional.
Very well.
It would, in essence, amount to an abdication by the state of West Bengal of its legislative and executive functions in perpetuity in respect of subject matters over which it possesses exclusive domain. By mechanical linking of the rates of DA to the AICPI, which is published by the Ministry of Labour, Employment, Government of India, the state would divest itself of all control and discretion in fixation of dearness allowance and would instead be irreversibly bound by the AICPI as and when published by the ministry.
Yes.
Your Lordship, if Mr. Ahmadi...
Mr. Ahmadi already concluded. You are arguing so well, you're getting an opportunity. Please proceed.
And we may not allow Mr. Hon'ble to argue him. We have already completed. Because we had thought of allowing 15 minutes to each.
Yes, sir.
So that we conclude today.
Yes, sir.
We will finish. After. This is repetition of the same thing.
Yes, we'll not be placing. Supreme Court
Mr. Bhattacharya,
issue.
the young council getting an
I
opportunity.
place it.
We are
On the
the court is allowing.
Then place it.
We also see. My lord has already said it was Mr. Sibal was not here. We had only one option. Thank you very much. Young council, we are just waiting.
Yes,
My lord has clarified. If Mr. Sibal comes, he will only sit beside her.
From her, and if she is doing so well, let her place it. I don't mind. I'm happy.
Mr. Hon'ble has to share today's whatever.
Supreme Court's view on the issue.
Yes.
Para 15. This issue has already been settled once by this court in the case of Tamil Nadu Electricity Board. It's part of the compilation of judgments which we had
We have
read.
seen that we have seen.
Yes.
Yes.
Similarly, para 16 also refers to 3 judgments
We
which
have
are
seen
part of the
that we have.
compilation. Yes, sir. 100% inflation neutralization. Para 17. The dearness allowance calculated by the central government is 100% neutralization of inflation. However, we submit that there is no mandate to do so by the state and neither is it advisable as has been settled by the Supreme Court. In the case of Kamani metals, Your Lordship,
Yes.
it can also not be said that if 100% inflation is not being neutralized, such action is arbitrary. Thus, partial neutralization of inflation by the state while fixing dearness allowance after taking into account various other factors is non-arbitrary exercise of discretion.
Very well.
Your Lordship, if we may turn to para 22 at page 9.
Yes.
We have listed 12 states apart from the state of West Bengal
who do not follow central government rules.
Yes, Your Lordship.
Correct.
And a table is also provided at Appendix 1.
Yes, very good.
Your Lordship, at page 10, there are two tables which we have summarized for your convenience. The first table deals with 4 states being Chhattisgarh, Himachal, Meghalaya and Sikkim,
Yes.
which have pari-materia rule regarding the definition of existing emoluments.
Yes.
In the event, this,
Read the dictionary.
yes, if I may also read the definition for Chhattisgarh, 3E, which is the relevant rule for Chhattisgarh, means the sum of existing basic pay and existing dearness allowance at index average as on 1st day of January 2016.
Yes.
Similarly, Himachal Pradesh,
Yes.
existing emoluments means dearness basic pay plus dearness allowance appropriate to basic pay admissible at AICPI average of 1510, because the scale referred there is
What
90.
is the language in other states?
Yes.
These 4 states are identical.
These 4 states, Your Lordship, are
Other states.
other states, Your
Who are
Lordship.
granting on central basis.
No,
The ones which are granting on central government. Your Lordship, we will have to check that once. But they are definitely not in, we'll have to check that, Your Lordship. We can,
The language is the same there also. Then what happens?
yes, Your Lordship. So, the language in the
Is
rule,
there any judgment of Supreme Court which
Yes.
deals with these AICPI issues?
AICPI issue. So, Your Lordship, there are judgments which deal with neutralization of inflation for the purpose of calculating dearness allowance and salary, which is Kamani metals. We will have to check whether there's anything specific to AICPI index.
Specific to, because we are specific on AICPI.
Yes, Your Lordship.
This whole litigation is about AICPI.
Yes, Your Lordship.
Is there any judgment of Supreme Court which deals with this, whether this index average should be read on the basis of AICPI or your own state's understanding of index average or inflation?
So, Your Lordship, with respect to your second query, states' discretion has
We
been
have to
upheld.
decide
Yes.
for all the states.
Yes, Your Lordship.
It seems.
Yes,
will
Your
be
Lordship.
applicable. Will not decide, but the law will be applicable.
Absolutely, Your Lordship.
So today you are West Bengal. Tomorrow some other states say we have evolved our own index average methodology, which is still less than what you are granting.
Yes, Your Lordship.
or more. Or more.
And with respect to your query on states' discretion being upheld for dearness allowance, the Tamil Nadu judgment has clarified that, but we'll check regarding ASC.
Read the paragraph 6.
Page 15.
Page 6.
Your Lordship, if I may just read the excerpt from the Tamil Nadu judgment at para 15, page 6. There is no rule or obligation on the state government to always adopt the dearness allowance as revised by the central government. Your Lordship, this itself clarifies and settles the issue that there is no obligation on the state to follow the AICPI, because it is a admitted position that the central government follows the AICPI. It is absolutely not necessary for the state government to adopt the dearness allowance rates fixed by the central government. It should be looked from the financial position of the state to adopt its own rates or revised rates of dearness allowance.
Yes.
Your Lordship, if I may now place the table which starts at page 12.
Yes.
So, Your Lordship, the first table essentially set out those states where the definition of existing emoluments was similar, and our submission to that regard is that in the event this court is inclined to hold that there is an inbuilt in ROPA 2009 an implicit formula for increasing DA rates linked to AICPI basis this definition, these 4 states will get affected.
Correct.
And similarly, Your Lordship, the second table In the event we are to leave aside this definition, and this honorable court holds that even without an explicit and implicit formula in the relevant ROPA, the basis or discretion of the state government to fix the rates of DA for its own employees should only be guided by and or 100% linked to the sliding AICPI index, which is the central government rate, without any discretion of the states. The following additional 7 states which do not follow the central DA rates also get adversely affected.
Yes.
Your Lordship, the factual matrix has already been placed by Mr. Diwan.
Now kindly come to page 40, the factual clarification.
Yes, Your Lordship. Your Lordship, these factual clarifications were placed by Mr. Diwan in his rejoinder.
That's right.
Yes.
And therefore, you kindly come to 43, additional points.
Yes, Your Lordship. That's
43.
Yes, Your Lordship.
Additional points.
Para 70. The upshot of the submissions of the respondents has been that it is explicit, if not at least implicit from ROPA 2009, that state of West Bengal is obliged legally to follow the AICPI published from time to time while declaring rates of DA. This argument is, however, belied from the tribunal's order itself, which you may kindly see at para 33 and 37 at volume 2, page 484.
Yes.
That it is the bounden duty of the state government to evolve norms, principles for payment of DA to its employees by calculating the same on the basis of AICPI published from time to time. It was on this basis that the Chief Secretary of the state was directed to evolve norms and principles.
That we have seen now. Delay and latches, what do you say?
Your Lordship, the period that we are concerned with is between April 2008 to December 2019.
If it is in their right and entitlement, suppose, then where is the question of delay and latches?
Yes, Your Lordship. If there is a question of right and entitlement, there is the only reason we've included this point is to describe the unreasonable time that they took to approach the court.
Thank you. So that's it. Thank you very much.
Grateful, Your Lordship.
So this side is over now. Please.
My lords, will restrict our submissions to.
We'll request you. Your कागज दीजिएगा, madam. We'll just request you. Say, true to her word, she's not taking more than 15 minutes.
Yes.
If in 10 minutes each one of you wish to conclude.
We don't need long.
Just one thing. The AICPI aspect is dealt with us from page 35. Your Lordships have seen.
You've seen that. Is there anything? See, what is it new that they've argued for you to rejoin?
Yes, sir. That's what we have restricted our submissions to. Please just hand over the short note.
We'll speak in 5 minutes because
We'll keep it
you
short.
are arguing to the rejoinder,
Yes.
responding to the rejoinder.
See, what we'll do is, we'll go through your submissions. Rest assured, we'll go through the submissions of
Yes, sir.
every word written there.
Don't read the submission.
If there's anything you wish to add orally, please do that. Otherwise,
My lords, I'll add orally, but I'll only take my lords to the parts that are directly.
We'll go through it. Don't
Yes.
worry.
My lords, Mr. Diwan argued first, in the first round, that the citation of the AICPI in ROPA 2009 was static. What does that mean? That leads us, my lords, to the somewhat absurd conclusion that the citation of AICPI 536 with reference to the series that 1982 is equal to 100 is only true for what they call the existing emoluments, that is 1 month. 1 month. So it would lead us to the conclusion that that index is only applicable for the month in which the ROPA rules were passed, and then that's it. Having our arguments having come in counter, my friends then argued, my learned friends then argued I think it was Mr. Divan, that no, now it is a hybrid. So they said that there is that static AICPI, but then after that, there are memoranda that come in, if my lords recall, where the state of West Bengal exercises its discretion in the memorandum. My lords, if I may ask, is that a fair encapsulation of the argument? I'm grateful.
No, we are not saying anything. So we are not saying anything.
My lords, the difficulty is this, that the Constitution doesn't allow it. Article 309 is perfectly crystal clear. And what Article 309 says, and only for this purpose, if I may refer to para 2 of my submissions. It states that absent an act of the state legislature, the recruitment and conditions of service of a person serving the union or the state shall be in the competence of the governor of the state or such person as he may direct in connection with the affairs of the state, and I quote, to make rules regulating the recruitment and the conditions of service of persons appointed to such services in force until provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act.
No, we'll request you not to read, please. You just highlight the new points which you wish.
So this is the point I'm
What
making.
you have said that there was a dramatic shift in the arguments. We have taken note of that. That it is static or non-static is one thing which you say. To what is your response to that? It is static or non-static?
My lords, the point that I'm making is that the rules have to have a complete answer.
Okay.
That you can't have the conditions of service regulated in the memoranda, because what the Constitution says in Article 309, that you must have it either the conditions of service, including DA. No, it's nobody's case that DA is not a condition of service. So therefore, such conditions of service must either be in the act of a legislature or it must be in a rule.
So therefore, what you're saying is it is there in the act and the rule itself, and not the memorandum. That's simple as that.
It's as simple as that.
Point well taken, ma'am. What else?
My lords, this I need not go into because my lords are well aware of these judgments. That rules override memoranda. You have Ajay Kumar Das, you have Ashokram versus the state of Maharashtra, you have Bank of Baroda versus Palani, you have, so this is all established. And my lords, when I say that the state has made dramatic shifts in arguments, I don't say this on the basis of just this hearing. I say this on the basis of a litigation that has carried on for 20 years.
Correct.
So the Advocate General, for example, the learned Advocate General of the state of West Bengal, had said that it is ad hoc. That it is being decided in an ad hoc way, yes, but it is because we are deciding it on the basis of the funds we have.
Very well.
Financial consideration, paucity of funds. Again, my lords have on a number of occasions said that paucity of funds is no excuse.
The right is there, it has to be, it's complete.
Precisely. Now, my lords, the statutory scheme in ROPA I have set out in the third part. And the reason I have set it out is because there will be an attempt to say to my lords that this is a very big matter. It has pan-India applications, etc. My lords,
It's a big matter, therefore you are appearing.
if only appear on sorts of matters. At this stage, my lords, the thing is that any decision of my lords has pan-India implications. This particular matter is restricted to this particular rule and the manner in which it is phrased.
Very well. Very well.
Now, what my young learned friend had just argued, and in fact, some people before her had also argued, I believe Mr. Diman had also argued it. They said that, look, we cannot follow the central government rules. This is not something that's binding on us. that we cannot make good 100% of the inflation that is occurring. Now, my lords, with the greatest respect, this is a straw man. This is an argument that is not in the room. A bit like my learned senior Mr. Sibyl. Nobody has made the argument that we should follow the central government rule. We are saying that the state of West Bengal, having enacted the rule, which happens to be identical to the central government rule, identical in its phrasing, in its reference to the ICPI, that they must follow that rule. You've made the rule, you follow that rule. So therefore, my part 4 refers to the state is arbitrarily applied.
That we have seen 1, 2, 3, 4 parts very beautifully. Now you can come to your part 5, please. Part 5 says that they themselves are following AICP, so therefore they are bound to follow it. That's it.
My lords, what I am demonstrating here is that they had consistently, until 2010, explicitly exercised their own constitutional jurisdiction to adopt and follow the central government.
So therefore, your right emanates from it.
So therefore, the fact that they then started following, citing the central government is, that's where my right emanates from, the 2009 rules, the arbitrary manner in which they suddenly said that this memoranda now occupies the field is something that doesn't even go with their earlier practice.
But then you have not answered that you have not challenged the memoranda.
My lords, with the greatest respect, the memoranda argument was made for the first time in this court after everything was filed. And I have set out what the state had argued before the tribunal.
Have your breath, Mr. Sibyl, don't worry. Have your breath, have your breath.
Sorry.
No problem. Yes.
My lords, before the tribunal, before the High Court in 2018, where the High Court said that due to the fact that the state government has adopted the 2009 rules, that it is now a legal right, and that matter, if I may, that principle, if I may again remind my lords, is now raised judicata. It was decided in 2018. So now to say, having argued throughout paucity of funds, financial incapacity, we have discretion, to now say that there are all these memorandums that actually have the answer, and that create some kind of valid legal right, having not, my lords, challenged the 2018 judgment. Now, after all these years, my lords, just to refer very briefly to my earlier submissions, that perhaps...
You need not refer to that. They've already heard your address.
But to wrap up...
Don't worry. We'll go through it. Every letter which is written there, we'll read. Don't worry.
My lords, Kerala's example is illuminating. Why? Because there are many other states that some of which follow the AICPI, some of which don't. But for example, you have the state of Kerala. They do not follow the AICPI. They have their own consumer price index. And they have exercised their discretion under 309 by enacting rules that have a basis in Article 14. Having adopted the rules,
yes,
pursuant to Article 309, it does not lie with the state of West Bengal at all. To say that now we are passing memoranda on the basis of our whims and fancies, which now give us the right to take away your vested rights.
Very good. Thank you.
I'm so grateful.
Anyone else this side? Yes, Mr. Bhattacharya.
Remember, the basic issue is very simple. This is no question.
Just one.
Sorry, if you want, you can sit here. Sorry.
Yeah, I'm sorry. The SIR matter was on. I was on my legs.
No problem. No problem. No, instructing police has done brilliant. We have gone through your submission,
Yes.
which you have given.
Yes.
All of them.
Yes.
Mr. Ahmadi was all, and the other team, your team was there.
Right.
So do you wish to add anything?
Just 5 minutes.
No problem. We'll give you 5 minutes.
Just 5 minutes, not more than that.
Yeah.
Because your lordship knows, because the domain and the jurisdictions are entirely different. Your lordships have seen that. The entries are different, domains are different. They can deal with their employees, we can deal with our employees. Right? So that's one part of it. Two, if they were to pass a law saying accept the DNS allowance as discovered by us, it would be unconstitutional because that would be encroaching upon our freedom. Right? So their entitlement is valid, but entitlement qua our notification. No doubt. They can't ask for beyond the notification. Now they are interpreting the notification in a manner to suggest that we have accepted the DNS allowance as well as decided by the central government. That's their claim. But our intention, we have reflected on affidavit that that's not what we want. Whereas our intention cannot be interpreted through a judicial decision making. No, this was not your intention. When we are saying it was our intention, and we have demonstrated that, then its impact on states. This is not a matter that will be decided by us. Existing emoluments is defined in several states where they are giving much less, including Himachal and other states, right? And those who are not defining existing emoluments, even they are giving less. So any decision by your lordships that what is decided in terms of the DNS allowance will apply to all states will have impact throughout, So therefore, it is my humble request, if your lordships are even inclined to do that, then your lordships must issue notice to all states, because then it can't possibly be that we are forced to accept DA decided by the union government, as well as the rest of the states, will not have to follow that. That's number one. The second argument is, your lordship knows that the genesis of this is under the industrial law. What used to happen was that an industry would have 3-4 regional offices, North India, South India, Western India. And the argument dispute used to be raised as to whether this DNS allowance should apply to other regions at all. And your lordships have said that DA is to be decided region by region. Why? Nature of inflation is different. Nature of the habits are different. Cost of living is different. What profits that particular unit makes in Ranchi would be different from the profit he makes somewhere else. So therefore, that has to be decided on region by region basis. Cost of living, purchasing power of the individual. What other benefits those people get, workers get, apart from this, which are not given by the central government. So there is it's not just finance. There is a complexity of issues, So please leave it to the state government. Don't, go by this, that because the existing emoluments were decided there had to be a base year, and therefore everything that is said by the central government must be applied to us. That's all we do. I'm sorry,
Deepest of respect,
Just 1 minute, My learned friend relied on Article 309 so as to suggest in a manner of speaking that if there is any kind of a vacuum in terms of the rules, then that will have to be decided by the governor under 309. What I wish to point out is your lordships are aware of Article 162, where the executive power of the government is coexistence with legislative power. So if today you have the legislative power under 162, you can always issue a notification unless, my lords, it violates the statute. And it's no one's case that the notifications violate the statutes, the notifications are not undercharged. The other aspect that is sought to be urged willy-nilly is that we were earlier following central government's rates. That nothing can be further from the truth. Up to 2010, the rates that were adopted, let's say, suppose the central government had a particular rate in 2006. I adopted that in 2009. I have never followed central government. So therefore, those instances we can give a note also clarifying that. We've clarified that earlier in our plea that we have never followed central government.
That all clarifications are made, that 3 review petitions are taken from different time to time. But the issue is not that the center is directing.
How much time it will take, sir?
Well, I just finished within 10 minutes. The issue is the entitlement of DA in terms of the statutory rules of the particular state. The rules of state of West Bengal is not going to govern the state of Chhattisgarh. These are all wrong conception. Now, all these issues were considered by the tribunal. Kindly will not come to page 482, paragraph 30. What is the defense of the state? The rule makers have understood the rules in a particular way and they have followed it till 2010. Now, suddenly after 2010, they wanted to divert. Whether the diversion was at all reasonable according to rules and according to the state government's attitude towards the employees. And kindly, when I just read out paragraph 30 of the judgment of the tribunal, it was upheld by the division bench. On review, that was also again without upheld. Here, Millard says what norms, principles have been followed by the state government for release of DA for its employees. No satisfactory answer in this regard came from Mr. Basu, learned counsel representing the state respondents. Mr. Basu has merely tried to impress upon us that the state government has followed the pattern of central government in releasing DA to its employees. But the state government could not pay DA at the rate and from the date paid by the central government to its employees due to lack of financial resources of state government. This is the stand. Rule makers appreciated how the rule is to be interpreted. They were not by the brilliance of the councils. And then the tribunal says, we do not say that you have to follow the central government. We say you follow your own rules and formulate accordingly. That kindly come to now paragraph 31. We have already observed that the payment.
Read, Mr.
I did not read. I just.
Give your submissions that what you are saying.
I say that
there is something new which you wish to add.
Nothing. I no substantial legal argument has been advanced by subsequent attempt. This is repetition of the old things, and they have to follow their own rules. Tribunal has directed the chief secretary. You formulate. But why didn't you formulate? Well, these are the simple.
Thank you. Anyone else this side? Thank you.
Sir, I am just stepping into the shoes of Mr. Gopal Subramanian. The written submissions on his behalf are there. I'll just hand it over. And additionally, there are some rules that we wish to place. There are copies of the rules that we would like to show. Just one submission that I'm not reading out anything. Just one submission that the entitlement flows from the service rules that the employees have. And the entitlement rules, entitlement is under the West Bengal service rules of 1971. That compilation of rules we have provided. Rule 93 of the service rules indicate.
Our request to all of you is whatever you are handing us to in court, you have to e-file it, please.
Please, we'll be e-filing it, and as well as with physical copies. With the registry, we'll ensure that.
Please.
So it's there on my lordship's file.
Yes.
May I go back to what that is Parchur's?
One more, sir. Pleasure.
Sorry.
Yes.
Rule 93 of the compilation rules, the rules which we have brought out.
Where is it? Which page?
Yes, this is page 74, internal at the bottom, page 70.
We don't have that.
We'll just give it. May I have page 74? Flagged at the top.
Yes.
74. Rule 93. A government employee shall be entitled to be paid while on joining time. Clause A. Under clause A of Rule 30, the pay which would have earned had he not been transferred, he will also be entitled to dearness allowance, if any, appropriate to the joining time pay.
This is my entitlement.
So, the rules itself provide my entitlement that I am entitled to the rules. I am entitled to the dearness allowance. And it is not the memorandums. That is what we would like to clarify. And the rules having been accepted in 2006, 1/1/2006 date has been triggered off, on which date AICPI has been accepted. Now, the rules clearly say that the formula which is there, your lordships have seen that, page 103, AICPI formula has been brought out. Therefore, it is implied and very clear that it will be the formula as per the AICPI. Now, that formula cannot be static. It has to change.
No, where are you reading the formula?
In the paper book. 103 of the paper book, your lordships have seen the ROPA rules. Existing anomalous. From here, I was only indicating page 74. The lordships have marked. This is rule 93.
Okay.
On the basis of rule 93, I am only indicating that the service rule provides that I am entitled to dearness. 103 of the ROPA rules talks of AICPI, the formula which is there, and it is not a static one. Therefore, with changing times, the formula will have to be applied. On the day it was applied, the emoluments and the salaries that we were getting were at par, and therefore it was at 0 level. And thereafter, it has kept on increasing, and therefore the formula will have to apply with time. It cannot remain a fixed thing. If that is the broad list, otherwise, we've given the written submissions.
Only one point I need to address in rejoinder. Mr. Diwan actually gave a rejoinder note, which is a note common to everybody, or it is only for Mr. Diwan. Two things which he primarily said was that no mandamus can be issued unless there is an entitlement and public duty is one. Second, what my learned friend just preceding me also wanted to impress, he said that these ROPA rules only provide a statutory framework for revision of pay structure. It does not create any entitlement for payment of any allowance, let alone DA, and it cannot be pegged to an index. This is what they are saying, that it was a one time and there is no question of any index. However, there is a very fundamental flaw in this. In the first round, your lordship is aware that this is the second round. The tribunal first held against us. We went to the High Court.
Yes, please.
In the first round, at page 375, that is the judgment, that is the relevant part of the judgment, which is rendered by the High Court in the first round, against which they filed a review. Review got rejected. There was no appeal. Your lordship may only note page 374, 75, para 24. I will read to your lordships. In fact, if your lordship has the second volume, precisely the same argument raised by the learned Advocate General and rejected.
In the first round?
Correct.
We are aware of it.
Then it says, apart from the fact that...
We have heard it. We have heard it.
Yes, your lordship is aware. It says, Mr. Kishore Datta, learned Advocate General, according to him, the findings of the tribunal that the claim of dearness allowance was not based on any legally enforceable right. According to him, the pre-revised scale of pay of the government employees has been transformed into band scale. According to the learned Advocate General, after initial fixation of pay under the ROPA rule, no formula exists for fixation of payment for the subsequent period. So what he said was, rule only, what Mr. Diwan also argued, was one-time fixation. There is no question of any further revision. This argument is considered in great detail. I had referred to that judgment. How does the consideration starts first by noticing the relationship between the employees, then noticing the concept of what dearness allowance is.
We appreciate that. Mr. Patwalia, can we just request one thing? Other than this, anything which you wish to add?
No, other than this, what I wish to say is that in the initial written argument which they filed,
in fact, what we are going to suggest to each one of you is this, that there are so many,
we should consolidate because while writing judgment, your lordship will need that also.
Comprehensive submissions first to be filed by the petitioners and then to be responded by the respondents.
Yes. Let us give a final submission of what we are saying in one.
That's what we
can.
So you will file it in how much time? That's all, Mr. Patwalia?
There is nothing much, your lordship. I've heard it for so long now. If I say something,
how much time?
Well, only one point I've been asked repeated and validly so. In the opening submissions which they gave, my lord, the state of West Bengal, they gave a common submission. Now there, and we have revised the CPI index. Now their written submission has turned on the head.
It's all right. What we'll do is, whatever they want to say, whatever, doesn't matter. Let them, we can't stop them from saying they have right to say also. Mr. Singhvi, would you like to also address us on this issue? Yes, Mr. Singhvi. Please unmute him.
No, Malik, I think, Malik, we have taken enough time, your lordships.
Thank you.
Covered most of the points. I don't want to add to that. Otherwise.
And your lordships have noted his presence, which is most important.
As if it's not important for Mr. Patwalia.
We are today only to say nothing more to say.
We have heard. Thank you. We have heard Mr. Sibbal, Mr. Singhvi, Mr. Ahmadi. I'm sorry, ma'am. What's your good name? Just give it a writing so that I don't commit a mistake. Add her name also. As also for the on behalf of the petitioner, also Ms. Karuna, Ms. Patwalia, सबका नाम लिख दीजिएगा. The respondents. Judgment reserved. We request the petitioners to file comprehensive. It is suggested on behalf of the Learned Council that let the parties file comprehensive written submissions. So we agree with the same. Let the petitioners file written submissions comprehensive in nature, dealing with all aspects argued before us within a period of
By next month,
whatever it is,
We'll do it within
2 weeks.
2 weeks.
And the respondents respond to the same within a period of 2 weeks. 1 week.
There are so many of us. Let there be 2 weeks if some intercede. All right, 1 week is also enough. 1 week is enough. 1 week is enough. 1 week is enough.
1 week.
Lords, one request and nothing new should be said.